with the stage directions. So today we actually are privileged once again to have the Secretary of State here, as well as the Campaign Finance Board, and they will be presenting information to us regarding the budget. And then later on, I will return the gavel to our distinguished chair, and I will be presenting a bill. So Secretary Simon, if you could please state your name for the record.
Great.
And you may begin.
Great. Well, thank you, members. Thank you, Madam Chair. Really appreciate it. Steve Simon, Minnesota Secretary of State. Thanks for the opportunity to be here. My understanding, our understanding, is that the Office of Secretary of State's base budget is going to be carried in the State and Local Government Finance Committee, as well as any non-election related change items. So I will be limiting my remarks today to the items that I understand are within this committee's jurisdiction, which are considerable. So
Mr. Secretary, could you pull the mic a little bit closer? Thank you.
Is this better? Okay. So as I was saying, just for the record, to make a clean record, I'll be testifying today only about those things that are within the purview of this committee. Our budget is divided. Some is in this committee, some is in Senator Murphy's committee. One of the first things I always mention when speaking about our budget is that our office provides $27 million more to the general fund than we cost. We cost about $14.8 million per biennium in general fund dollars, and we make $27 million above and beyond that, which is pretty extraordinary when you think about it. It's not as if we cost $300 million and we make 27. We cost $14.8 million and we make $27 million extra dollars in that. So we're a small profit center for the state. By the way, that is because of the fees that we charge over on the business services side for various business filings, and we do not set the fees. You do. The legislature does. So I mention that because those fees, by the way, have not changed, most of them since the 1980s. We haven't raised any of them. And again, we don't keep any of that money. That $27 million is not something we keep. It all goes to the general fund. So I think it's just important to remember that our office makes significantly more money than the enterprise costs. I also want to ground the discussion in a history of general fund dollars for the Office of the Secretary of State's base budget. Julie Strother, who's sitting to my left, is our Deputy Secretary of State, and she once famously, after having looked into our budget going back to the early 90s, concluded that the history of our office's budget since that time has been that it has been aggressively flat. I like that term, aggressively flat, if that's even a such thing, if you can get your mind around that. And that is true. Even not accounting for inflation, let alone, that's the next slide. I'm building up to the next slide. Just even if you don't account for inflation, we are essentially, as you can see, at 2002 funding levels, despite growing needs, growing population, growing demands across all divisions of the office. Now, on the next slide, it's even worse when you adjust for inflation. If you adjust for inflation, the base general fund budget of the office has been substantially reduced over time. Before I go into our budget requests, I want to remind you of one thing that I shared during my office overview. If you recall, I was before this committee to talk not about the budget, but just our office, what we do, why we do it, et cetera. And that is that our office serves the whole of Minnesota, obviously. And yet, the election-related staffing within our office is quite lean. The elections division of the office is only 21 full-time employees with one general counsel, that's it, one, that serves the entire Office of Secretary of State. 9 of those employees, including our elections director, serve as election administrators supporting primarily the 87 counties and hundreds of municipal election workers. They are our partners, they are our teammates, they rely on us, and we rely on them for things as well. The office also maintains 9 IT staff supporting our many online tools for voters, namely the statewide voter registration system, or SVRS, which is really the backbone of the entire election system. It's the big federally mandated database that we and other states have that contains basically all the information and all the data needed to run the system, as well as other tools such as our election night reporting system, candidate filing system, among several others. And new to the office is what we originally called an election cyber navigator, but we really have since started calling that person our election security navigator. This is one person and a deputy, 2 staff total, funded by Help America Vote Act funds, and they're tasked with working with all 87 counties to help secure our election systems. And finally, as you'll see, we have 1 full-time voter outreach professional and a temporary voter outreach team member. It's a small team, it's a mighty team, but they support all 87 counties. They have a ton of work to do, particularly at election time. Thousands of election workers, from township clerks to county auditors, tens of thousands of election judges, and the over 3.6 million registered voters in Minnesota rely to some extent on them. Next, I'll just say that leads to our first request. We need to grow the team. They are stretched, they are strained, and that's putting it mildly. So the first request is for $559,000 per year, or $1,118,000 each biennium, to add 6 FTEs to support our election administration and voter outreach work. It's critically needed. You can see from those charts and graphs, I don't lightly come to the legislature, at least in the 8 years I've had this job, and ask for FTEs. You can see that. So we do it when we really, really need it, and we do now. So these 6 positions would break down as follows. 3 FTEs supporting election administration, directly supporting our county, city, town, school district election officials, and supporting the voter systems maintained by our office. 1 FTE would be supporting the voter outreach operation. The need for voter education and outreach continues to grow. It's really exploded. Our partners all over the state, they just want data. They want information. And not just data information, that they can get on a website. They really want participation from some representative of our office to show up, to host things, to interact with people all over the state. So this will ensure that we can continue to partner with businesses, with schools, with nonprofits, with community groups, to provide information to voters on how to vote and how to be engaged in the process. We also are proposing 1 FTE supporting election and voter communications and information. It's similar to the outreach position, and this would really be to support the work of the office to provide clear, comprehensive, and accessible information to the public and to voters about the election process. Huge demand over the last few years, huge, even at a time of a once-in-a-century pandemic. And so they really are at the point of bursting. And the idea is we don't want to let down the people who really rely on those services, and the volume is intense. And the last FTE is for a deputy general counsel who would support our 1 in-house attorney in compliance issues related to elections, grants, as well as ensuring the office can timely and comprehensively respond to the growing number of data practices requests related to elections. I'll just underscore, and a lot of people informally tell me they're shocked to know we have 1 lawyer. That's it. 1 jack of all trades who does everything under the sun in our office. And that really isn't tenable going forward any longer. It's probably also not a good practice to have everything reside in the brain of 1 person, however good that person is, and she's really, really good. But we need someone to lighten that burden. Next, I'll just say that these additional staff are needed to support the growing needs related to elections in our office. And while there are examples of obvious reasons for increased needs, the addition of a 3rd statewide election every 4 years is an example, the presidential nominating primary. That wasn't there a few years ago. So now our partners, every 4th year in the presidential year, what we've told them is, and what the law tells them is, you now have to run a 3rd statewide election, not just the November general and the August primary, but oh yeah, there's this presidential nominating primary, which, members, is a year away. Voting, election day will be early March, but a year from now we'll already be in the middle of the absentee period for the presidential nominating primary. But there are other things as well. So I want to mention that there has been turnover in our local election administration ranks. Since 2020, 1 in 5 lead county election officials is new. These are dedicated local election professionals that are really the backbone of the system, but a rapid increase in new professionals means increased training and support needs at the state level. And there's a real demand on our office for that, as there should be. They turn to our office, we help train the trainers, but there has been considerable turnover. Another less obvious need is related to election equipment certification. Some of you know that that's one of our responsibilities. We don't buy the equipment, we don't own any of the equipment, but we do certify it. And the rule in Minnesota is a belt and suspenders rule for equipment, which is that as the legislature has long dictated or said in statute, no piece of elections equipment may be used in an election in Minnesota unless 2 things happen. It's 2 layers of review. First, it has to have been certified by an independent federal lab at the federal level. Then and only then is it even on the menu for our office to try to certify. And only if it's certified after a public process, then and only then can it be used by any county or township or city in Minnesota. But for a significant period of Minnesota's modern election history, there was only one primary equipment vendor in the state, one that had a ton of market power. Now there are 4 different equipment vendors certified in the state with 12 different pieces of technology. This variety and competition is a good thing. It provides options for our counties. It provides a menu that they can order off of. But our office has to test and certify each piece of equipment, and it's a long, drawn-out, meticulous process, as it should be. We're not asking for that process to be shortened. It shouldn't be. And I wish more people would show up to the public process so they can see for themselves all the paces that these pieces of equipment are put through. But the growing number of pieces of equipment has put pressure on the administration team that conducts that work. They do it very well, they do it meticulously, but they are stretched and they are strapped. Finally, the work of the team to process grants and reimbursements has grown significantly. Since 2017, our office has handled over $20 million in state and federal grants to be distributed to counties, cities, and townships throughout Minnesota. These funds have been critical for aiding our local partners, but the administration of those grants places a real burden on our office. And it's important to remember that our office also processes over $9 million in reimbursements to local governments for out-of-pocket costs for administering the presidential nominating primary. So that's above and beyond all of that. To put this in context, in the period between 2011 and 2017, our office administered less than $1 million in local grants. Now it's a lot more than that. It's been $20 million since then. And that takes time because you want to do it right, and you have to do it thoroughly, and you have to do it meticulously. The next request is for additional security related to our election division. This is a funding request that we made in the previous biennium following an assessment done by our federal security partners. This is the Department of Homeland Security who went in and did a security audit. That's what they did. They paced up and down, they looked around the building, they did a lot of troubleshooting, thinking of worst-case scenarios, and they came up with these recommendations. Because half of this request is related to our business services division, I just note, as you'll see there, that the request related to elections in particular would be about $100,000 per year or $200,000 per biennium. The final 2 requests are one-time funding requests. And the first of the 2 is the state match requirement for the Help America Vote Act, or HAVA funds. Many of you are familiar with this from past sessions. Our original budget request was for $230,000, but since submitting that request, the federal government has appropriated another round of federal funds. So the bottom line is we're asking for a little north of $460,000 to unlock about $2.3 million in federal HAVA funds. And for those of you who may not be as familiar with this, this is what Congress has taken to doing this last few years, particularly since 2016, is they'll dole out kind of on an unpredictable basis, to be honest with you. It's not routine, it's not annually, it's not 2 times, it's not every 2 years, it's sort of like whenever. They will dole out chunks of money to the state, but they've started asking for a match. They want states to have skin in the game. So they've asked all states to come up with 20%, they'll provide the 80%. And that money, by the way, is waiting for us to use. It's there and waiting for us. We just need to unlock it by getting the 20% match, which again is about $460,000, a little north of that. Next, I just want to talk about how the federal government limits how these security funds can be used. There is strict oversight. They require, it's federal money, they're watching. We have to do reports routinely on how we're using that money. They do audits of us in terms of how we're using that money. We have to file a spending plan with the Election Assistance Commission, or EAC, which is a federal agency, and we have to submit quarterly financial reports. So you are free, of course, always, and I believe in oversight. Doesn't matter who's in charge, what party, whatever. It is an absolutely core, legitimate legislative function. Of course, I don't need to tell you. So you can do yours as well. I just want the committee members to know that there is already vigorous federal oversight of these particular funds. Finally, the last request is with respect to redistricting litigation fees that our office owes as a result of the 2022 redistricting being conducted in the courts. Our office was what's called the necessary defendant here, which is sort of interesting because we have very little to do with redistricting. We don't draw the maps, we don't do any of that stuff. We have a small kind of ministerial role towards the end, but that's it. But every 10 years, like clockwork, the way it's styled in court is it's always such and such plaintiff versus the Office of Secretary of State. That happened this time to the tune of several lawsuits. In fact, a couple of our favorite plaintiffs are sitting behind us. It's nothing personal, never is, but all the litigation related to redistricting is typically resolved at the end with an attorney fee award. And every year, like clockwork, whether it's me or Secretary Ritchie or Secretary Kiffmeyer, it comes out of this office's budget. So basically what we're asking for is, I think it's in this slide, right? It's about as of February 9th, that's right, about $486,000. The interest meter is running. So the sooner you could see your way to appropriating that money, the better, really, for the state. You could save $10,000 by, at least, if you paid these fees today versus July 1st, because the meter is running. But that's just an obligation that this office faces every 10 years, pretty much like clockwork. The court, as you can see from this quote, understood that the costs associated with this necessary litigation would ultimately be paid by the taxpayers. As interest is accruing, again, I hope we can work together to pay this amount quickly to avoid further costs to Minnesota. That, members, is all I have for now. I wanted to be hopefully quick and efficient. Happy to stand for questions now or later about our budget, but that in sum and substance is what is before you jurisdictionally that pertains to our office. So thanks for your time and attention.
Thank you, Mr. Secretary. I think we actually would like to hear from Peter Watson first, and then we'll take some questions. So, Mr. Watson, if you could make your way to the table, state your name for the record, and then you can begin your brief testimony.
Madam Chair, members of the committee, good afternoon. My name is Peter Watson. I live in Shorewood, and I was the lead plaintiff in the case called Watson versus Simon, which caused the districts from which you were elected to be drawn. The Watson plaintiffs were joined, there were 7 of us in the Watson group of plaintiffs. We were soon joined by the Anderson plaintiffs, 7 people who said that they were representing Republican voters. And shortly after that, we were joined by the Sachs plaintiffs, who said that they were representing DFL voters. Later on, a group called the Corey plaintiffs joined as well, and they said that they represented Black, Indigenous, and people of color voters. I'm here to support the Secretary of State's request for this money, and in order to give you historical background on the need to make these payments, I created this little document. I think you have a copy of it in your folder. And what it shows is that, as the Secretary suggested, this kind of thing is not new. It's not unexpected. In fact, we're now the 6th decade where a court has ordered the Secretary of State to pay attorney's fees to plaintiffs who were successful in a case that required the drawing of either legislative or congressional districts or both. I want to call your attention on the first page in the middle, the redistricting case from 2013, the language that I think gives rise to the Secretary's mention of interest and how interest is accruing, that the sum of attorney's fees is supplemented, increased by interest that begins to accrue the day after the award was laid down, August 31st, and is continuing to build up every day as we go on. Also want to call your attention to the last sentence. This appropriation is available for an expenditure the day following final enactment. So the sooner you get this appropriation enacted, the better. And I might suggest you give serious consideration to perhaps putting this appropriation into a separate bill, a standalone bill that could be enacted earlier. There may be other agencies that have deficiency appropriations for the current biennium who would benefit from that kind of a process as well. So if you have any questions, I'd be happy to answer them.
Thank you, Mr. Watson. Members, questions? Senator Swedzinski.
Thank you, Madam Chair. So if every 10 years after every census we have this litigation, do either of you two in your infinite wisdom want to parlay anything, bestow upon us, something that maybe 10 years from now, when we face this next litigation, and by then it could be $750,000 bill, that we can avoid the legislators that are going to be sitting here in 10 years, this very hearing? Do you guys have any insights into that? We'd appreciate that. Thank you, Madam Chair.
Senator
Mr. Watson,
Sludzinski,
go ahead.
Madam Chair, Senator Sludzinski, of course, one way to avoid it would be for the Senate and the House and the governor to agree on a plan and enact it into law. But Minnesota has perhaps been blessed by having divided government, so that doesn't happen. Senator Rest carried a bill a couple of years ago, 2019, 2020, that would have created a commission to draw the districts so that regardless of whether the legislature was divided or not, and whether the governor was of the same party, the districts could be drawn without the need for court intervention. So that's one possibility I might offer for your consideration.
Any other questions? All right, well, thank you so much for your time today. Thank you for presenting the information. We are going to move on to the presentation from the Campaign Finance Board. Good afternoon, Mr. Sigurdson. If you can state your name for the record and then go ahead and begin with your presentation.
Thank you, Madam Chair. Jeff Sigurdson, Executive Director of the Campaign Finance and Public Disclosure Board. Having assumed that I've sort of wore out my welcome in terms of PowerPoint presentations after our discussion about functional equivalent, I've decided to go without a PowerPoint, but I am assuming that members have within their packet the governor's recommendation for the Campaign Finance Board because it has attached to it. Okay. That was my miscalculation. It has attached to it the two line item changes that I wanted to talk to you about today. Briefly, the board currently has for FY23 a budget of $1,167,000, which allows for an FTE of 8.4 positions. The executive director, the assistant director who's an attorney and is involved in investigations, 2 IT positions, 2 legal management analyst positions, which again conduct investigations for the board, 1 program administrator for the lobbyist program and the economic interest statement program, a compliance officer who basically helps treasurers and other individuals file reports, and then we do have a part-time position for filing and mailing our mass mailing.
Madam Chair.
Senator Rest.
Mr. Sigurdson, we actually don't have that information, and I mean, I wouldn't want to interrupt your presentation, but if you could make sure that we get a paper copy after the presentation, it would be much appreciated.
Certainly, Madam Chair, Senator Rest. Again, this was actually the governor's recommendation on their website, so I apologize for just making that assumption that you would have that, but it is available through the governor's website.
Thank you. We'll make sure to get a copy of that for everyone.
As part of the budgeting process, I am just to step back for just a moment. All agencies receive a projected salary for the upcoming biennium, and that projected salary is just looking at the current positions that the agency has and looks at the projected step increases. It doesn't try to anticipate any negotiated across the board increases that ASME or may come to with the state, but it just looks at projected step increases. And when I looked at that, I realized that the step increases for the upcoming biennium would take us up to approximately 85% in the first year and 89% of the entire budget for the agency. And when you added that in to the fixed costs, which are minute charges that are for IT services provided, mailing costs, which are statutorily required, and our rent costs, our overall budget then was between salary and fixed cost at 96% of the amount that we would have had without an increase. So that's why the board asked for a line item or a change item increase of $110,000 per year again, to our base operating budget. That reduces the amount of the budget that goes, again, for salary and fixed costs down to 87%, leaving approximately 13% for things like office supplies and so, lease, copier leases and other items which you have at least some discretion over. Without that increase in place, I don't believe it's possible to operate an office on just 4% of the budget, and so it would have required us to reduce staff by one position. I realize one position may not sound like a lot, but again, when you have an office of 8, that's a 12% cut, and would make it extremely difficult for us to maintain the programs that we have that provide disclosure to the state and to the public and meet the other requirements that are set for us in Chapter 10A. Again, I want to emphasize rather that the requested increase will allow us only to maintain current staffing. There is no increase to staffing in the change item. It just allows us to maintain our current staffing of 8.4 positions. The other requested increase is to move basically the board's IT resources into a much more secure situation. Currently, to describe it, we are operating a little bit, I'm not quite sure how to put it, but it's certainly not up to date. Our servers literally sit in our office space. They're not in an air-conditioned room. They're not in a fireproofed room. They're simply sitting there. We do have continuous backup at a remote location, but nonetheless, we do not have the most modern of situations, and increasingly, the data that the board collects is immediately put onto our website. Applications for reporting are supported through our website, and we simply need a more modern approach than to have servers sitting in our room. We've approached Minute and have talked to them about what it would cost to move our resources, our IT resources, to the Azure cloud. Azure Cloud is a Microsoft cloud solution that is being offered through Minute to all state agencies. The estimate from Minute is $50,000 per year to move all of our resources to the cloud. That has a lot of benefits. Backup is now automatically done through this, through the cloud-based solution, and frankly, it's done in multiple locations. Security is obviously at a much higher level than when you have just 2 IT persons trying to keep things patched and the firewall maintained. Now that's something that Microsoft conducts, and again, in their cloud solution, it would be much more secure for the office. It would also allow us to be instantly scalable. We're moving to a situation where most reporting is done through our website, including in the future, all of your campaign finance reports will no longer be PC-based, they'll be web-based. And we need to have a scalable solution so that if we need the ability to scale up the number of processors, the ability of the amount of memory available, that we can do that more or less seamlessly, and that it won't be affecting clients as we try to resolve those and respond to any issues that may arise. And to me, one of the more important issues is that I'm now able to then turn my 2 IT staff to actually supporting the agency and supporting the clients. Now they spend an awful lot of time patching things and worrying about Microsoft updates and doing things like that, which are certainly part of what they need to do, but it really doesn't have anything to do in terms of improving our databases or improving our online applications to help our clients file and meet the disclosure requirements in Chapter 10A. So again, that's another $50,000. So in total, the board has asked for, and the governor has included in his budget, $160,000 above the base to meet those 2 line items. I'd be happy to take any questions, Madam Chair.
Thank you, Mr. Sigurdson. Does anyone have questions? Anyone? All right. Well, thank you so much for being with us today. And now it is with great reluctance that I return the gavel to our esteemed chair so that I can present my bill.
Thank you, Vice Chair. Vice Chair Weston. We have a bill that Senator Weston is going to be presenting, and It is Senate File 1283 on soliciting in polling places. Senator Weston.
Thank you, Mr. Chair and members. Grateful to be here today presenting this bill to you. So just to set the stage, and then we do have one testifier on the bill. Currently, Chapter 211B deals with fair campaign practices, and 211B.11 subdivision 1 is specifically details the prohibitions on soliciting at or near polling places. And, you know, in Minnesota is probably the case with many other jurisdictions. We have attempted to carve out our polling places as an island of calm where people can go vote in peace, and setting a distinct separation between the act of campaigning and the act of voting. Our existing law states that there's a prohibition for campaign materials and solicitations within a polling place or within 100 feet of the building. But it also goes on to talk about a prohibition on political badges, buttons, and other insignia. And that is where our state statute ran into a little bit of trouble. The Supreme Court heard a case and ruled in Minnesota Voters Alliance versus Mansky, wherein the court found that while the state's prohibition on political apparel did serve a permissible objective with this idea of trying to create a campaign-free zone for people who are attempting to exercise their right to vote, that doing so was a line that was drawn by the state. It had to be reasonable, and the state had to be able to articulate a sensible basis for what was allowed in the polling place and what was not allowed in the polling place. And in essence, the Supreme Court, U.S. Supreme Court, found that the use of the term political was pretty broad. The statute did not provide an actual definition of that term, and what that ended up happening in practice is that election judges were put in the position of having to make a determination of what was political speech or political apparel or political buttons and what was not. And there wasn't really a clear, bright line definition for election judges, and not really any specific guidance that would be helpful to them. And there was some concern that this also would end up being subject to bias. One person's political item may be another person's, I don't know what. So the purpose of this bill, with that as the background, is really to bring our statute in line with the recommendations or the order of the Supreme Court. And I do wish to move Senate File 1283, but I also wish to offer an author's amendment, the A1 amendment.
Senator Westlin moves an author's amendment, A1 amendment to Senate File 1283. All in favor, say aye. Aye. All opposed, nay. The amendment is adopted.
Thank you, Mr. Chairman. So, and the A1 amendment conforms this with what has passed through the House process. The first part of the Senate file, you'll look on lines 1.6 and 1.7. Initially, it says a person may not display, and the language has been changed to must not to make it clear that it is an actual prohibition. But the amended language carves out the fact that we now have people voting absentee in person where that wasn't as common previously. So this new language basically states that during voter hours, throughout the absentee period, and also on the day of election, a person must not wear, exhibit, or distribute in a polling place or within 100 feet the name, likeness, logo, or slogan of a candidate who appears on the ballot, the name, title, subject, slogan, or logo of a ballot question that appears on the ballot, or the name, likeness, logo, or slogan of a political party. And so this really does narrowly tailor the statute to make it easier for our election judges to understand what the bright line rule is, And it conforms with the Supreme Court decision that found going beyond that infringed on First Amendment rights. So that is the information that I have to present on the bill today, and would have our testifier
And
come
Senator
join
Westlin.
us, either the
Senator
Secretary of
Weston,
State.
you have a testifier, the
Yeah.
Honorable Secretary of State.
Okay.
Mr. Secretary, please identify yourself again and proceed with your testimony.
Thank you, Mr. Chair and members. Steve Simon, Minnesota Secretary of State. It's a pleasure to be here to say a few words in support of Senator Westlin's bill. I think for two major reasons. One has to do with the substance, one has to do with the procedure. As you've heard, the Mansky case, and we have Mr. Joe Mansky behind us. How cool that 100 years from now, there will be a Supreme Court case, 200 years from now, 300 years from now, that's named after him. Not everyone gets that honor, but there it will be in the law books forever. And that case, of course, was a Minnesota case, as Senator Westlin told you. And this bill really conforms to the line that most people think the Supreme Court was drawing, which is to say you can't just say it's too broad on First Amendment grounds to say you can't wear political stuff in the polling place. Too broad. You're forcing election judges to become experts and have a catalog in their head of what is political. What if someone walks in with a "I'm with her" shirt, or "Let's go Brandon," or whatever? It requires election judges to have this catalog in their mind of things that might be political. They may know, they may not know. So the line that they appear to have drawn is the one that I think Senator Westlin has done a good job of capturing, which is, okay, you can prohibit, you can limit apparel or other items that are related to a candidate or a ballot question on the ballot that day. And that, I think, is a sensible choice. That's how most people around the country have viewed the Mansky decision, what the court said. I can't say they said that explicitly. They didn't. They more said what isn't permissible than what is. But the line that most people around the country are drawing are that. So if this bill were to be enacted, if you want to walk into a polling place, if your constituent wants to walk in with their Tim Pawlenty hat or their Mark Dayton T-shirt, that's okay. But they can't walk in with something bearing the name or likeness or logo and the like of someone on the ballot that day. Because, as the Supreme Court and other federal courts have said, you know, that's politicking, that's electioneering, and you can't do that. But in terms of issues, unless it's an issue that's on the ballot, if you want to walk in under this bill and otherwise with a T-shirt that says I'm pro-choice or I'm pro-life or I support the Second Amendment or whatever it is, you can do that. Unless that's a ballot question that's somehow on the ballot that day. So I think what I'm saying is that I think Senator Westlin's bill draws the line that most people believe that the Supreme Court in the Mansky case have drawn. The second reason I'm here, really quickly, has to do with the procedure, which is I think this kind of cleanup in light of litigation is a real public service. Whether you agree or disagree with the Mansky decision, our constituents in Minnesota, if they look at the statute books, look at what's on the page, are going to find this law, and there are other examples that we'll bring to you in a separate bill that I've talked with some of you about. There are laws that haven't been changed in light of litigation. I'm thinking of several, and we're going to have as many as we can correct this year, but this is a really big one. This case came down in 2018, but if one of our constituents were to turn to the statute books, they'd see on the page in black and white a law that says you can't wear anything political. We now know that the court, in essence, struck down the reach of that law or limited the reach of that law. And so if nothing else, even, and there are reasonable minds can differ here on whether the Mansky case was correctly decided or incorrectly decided, but it was decided. And so if nothing else, to conform the law for the benefit of our constituents, I think that's a good thing. And I think Senator Westlin's bill has drawn the appropriate line, the one that legal scholars and others, whether they agreed or disagreed, believe that the court has drawn. So thanks, members, for your time and attention.
Thank you, Secretary Simon. Do we have any questions?
Mr. Chair? Oh.
Senator Matthews.
Senator Grant.
Oh, okay, Senator Grant.
Thank you, Mr. Chair. Senator Westlin, so this Secretary Simon just talked about its clarity, and I think we've all seen those where the courts were seeking legislative clarity. Does this get there? And have we had opinions, or I guess if the initial question is Secretary of State's office create this language with their expertise?
Senator
Mr. Chair?
Westlin.
Is that a silent testimony?
I guess I'm not sure where this originated from. It appeared on my desk. It seemed like a really good idea.
Ms. Freeman, please identify yourself and proceed.
Thank you, Mr. Chair, members. Nicole Freeman, Office of Secretary of State. Our office provided feedback to this language. It was a bill, the bill was introduced the last biennium as well. And sort of based on that bill, we've provided feedback working with the House author and other members, House and Senate research.
Thank you, Ms. Freeman.
Yep.
Mr. Chair?
Senator Grant.
I can appreciate, I think that your amendment does expands what a voting period is, so whatever we decide it applies, and to me, that makes sense. It still seems like it's a fairly arbitrary, or still seems to be, there's some pretty big gaps. We've seen emblems and symbols and shirt colors be tied to, this whole Capitol, every day you come in and as a legislator, it's like, oh, I wore an orange shirt today or a red shirt today, and suddenly you're being hated or thanked, and so it still appears to be a very broad scope there, what can be determined in the variety, and I know it changes locally based on whatever the initiative is, from St. Paul trash hauling, whatever the heck their emblem was, to it seems like there's still a fairly large gap, or it leaves it to be a subjective opportunity for somebody to remove somebody in a polling place, and there is some clarity. They think the real piece, the logos, a campaign, candidate name, all those things, we all agree with. I think that, within 100 feet. But I still don't think I still think it's pretty broad. And so when we talk about campaign initiatives, and so is a red hat with no lettering going to be interpreted as being tied to a political party or a political candidate?
Mr. Chair.
Senator Westlin.
Thank you, Senator, for the question. I actually think that this narrows things to kind of three buckets. If you're displaying something that specifically is the name, likeness, logo, or slogan, to me, that's pretty bright line language of a candidate. So you can't wear anything that's specifically related to a candidate. You can't wear anything related specifically to a ballot question on the ballot that year. And then you can't wear a political party. I couldn't walk in with a DFL shirt if there's a DFL person on the ballot. So from my perspective, I think this actually narrows it, the buckets. Now, if a red hat is a red hat, a red hat is a red hat. Sometimes hooves are horses and not zebras. So I actually think that this takes away the discretion quite a bit from an election judge that has to make that decision. So an orange shirt without any other things on it, if there's nothing on the ballot, I think that does provide a bright line rule for our election judges. So I think the plain language of the proposed bill, I think, actually addresses this in a much easier way than for someone to have to determine what is a political statement. And we may see it differently, but I think it's a little easier for our election judges.
Mr. Chair, just a quick
Senator
follow-up.
Grant, follow.
Thank you, Senator Westlin. And I just think that we've seen the creativity of emblem, whatever we call an emblem, or the definition of an emblem be expanded, right, in the creativity of just a shirt with one stripe on it. Well, is that an emblem, or is that a logo? It could be tied to, if there's some other printed material that's obvious, you could call that out. I think it still puts the judges in a very difficult position. Some clarity. I think the candidate stuff, anything that's named in a very distinct issue, I got that, and I think we all agree. I'm just not sure it meets the full intent or avoids that future lawsuit of somebody being removed for an arbitrary opinion of an election judge in any facility. So I hope it does provide some clarity. So thank you.
And Mr. Chairman, not to beat the
Senator
dead horse,
Westlin.
but I do think that it does specifically state that it has to have some objective indication. So Again, an orange shirt might be associated with a particular group, but if it's just an orange shirt, it's just an orange shirt. And so I think that, especially for candidates, you know, if a candidate has a particular logo that's on their campaign literature, pretty easy.
Yep.
Parties is pretty easy. And again, I think because it's limited to a ballot question actually on the ballot, again, I think there will be materials out there where that ballot initiative may have a logo associated with it. And so I think that as best as we probably can get, I think that this gets to where we're trying to be, where there is as much of a bright line rule as possible so that our election judges have some sort of more objective criteria.
Mr. Chair, and then just a quick.
Senator Cran.
Thank you, Mr. Chair, and Senator Westlin, and I agree, but I do think that we've seen everything kind of weaponized in a symbolic manner. I've said on multiple mining events where pro-mining is a blue, solid blue, anti-mining, orange. Interesting, all from the same political party, by the way. But I think we'll see the migration of those, and I guess there will be refinement of a of a definition of what is a political statement. So I still think there's broad room for subjective, but I appreciate your comments. Thank you.
Mr. Chair, I just learned something new. Thank you, Senator
Senator
Cran.
Westlin. Senator Westlin, a question for me is that does this still leave the prerogative of the election judge to make a judgment? For instance, I've heard enough incidents where someone comes in with something that people don't understand, and the election judges have made them turn their shirt inside out or zip up their jacket, something like that. Is that still allowed?
So, Mr. Chair, so the election judges are sort of the enforcers. And my understanding is they get something that provides them direction as part of their training in terms of what's permitted and what is not permitted. I think this will make that process a bit easier for them. And they do have the ability to ask the voter to remove the item. So it does fall on the election judges to enforce this.
Thank you. Senator Matthews.
Thank you, Mr. Chair. I have a few questions similarly. First, either to the Secretary of State's office or to you, Mr. Chair. We got a document in our handouts dated June 25th, 2018 on county election officials displaying campaign materials in a polling place. I'm wondering if this, it doesn't state explicitly, but I'm wondering, is this the Secretary of State's guidance in that election year after the Supreme Court ruling came down?
Senator Westlin. Senator Ms. Freeman.
Thank you, Mr. Chair. Yes, that appears to be what it is. I can say affirmatively that our office did send out guidance that looked a lot like this. I'm not sure, was this from a link on our web? I didn't send this in, so this link in. I'm thinking that it's provided on our website, though.
Mr. Chair.
And
Yeah.
is-
Senator Westlin, from what I understand, this was provided by the House author.
Okay.
And, sorry, and my understanding is that, given the date and given that the case was decided on June 14th, 2018, it was probably an attempt to try to comply with the new Supreme Court, but I'm not sure.
Yeah, Mr. Chair.
Senator Matthews.
Thank you, Mr. Chair, and I appreciate, and I get, as far as you can tell, sitting here in the moment, it appears, and I agree, putting pieces together, it seemed that that's what it was. So, Mr. Chair, the document describes, it basically went after names. The whole subject of the advice, which I thought was really good advice for that 2018 cycle, basically focused on names. Name of a political party, don't do that. Name of a candidate, don't do that. Something in support or opposition of a ballot question. And so, going off what Senator Cran was talking about, like Senator Westlin, you talk about 3 buckets, but I'm looking at, you kind of 4 quadrants in each bucket. And some of them I think are clear. Name, logo, slogan maybe. likeness and kind of slogan two starts to make me wonder if we're sliding back into what the Supreme Court prohibited of if you don't have a clear and definite dividing line, then the purpose is self-defeating. Their own interpretation of the rules won't give that island of peace for our voting. So I guess I'm wondering if the advice heavily focused on names and political parties, have we had problems expanded beyond names we've had 3 election cycles since this ruling, 18, 20, and 22. Do we have reports of something being an issue beyond names to why we're including a logo, a slogan, a likeness? That's what I'd kind of put, if we had an amendment that just focused on a name, a party, something like that, I think we'd all get behind that. It's a couple of these other terms that make me start to wonder if we start getting fuzzy again.
Mr. Chair,
Senator Westlin.
Senator Matthews, so I think the problem is if you just do the name, it is then possible to walk in not just with a red hat, but a MAGA hat, or the slogan, "Make America Great Again." And that is associated with a very particular candidate. So I think that by adding the likeness, so I assume that you can't wear something that has a candidate's picture on it. And if there are slogans that are specifically associated with a candidate, people will have heard the slogan enough that they will associate that with that candidate. So I think the name only is probably too narrow. And so my understanding would be that the attempt here is to make sure that when someone enters the polling place, they aren't wearing anything that is intentionally meant to persuade a voter about a particular candidate, a ballot initiative, or a party associated with a candidate. So my opinion, and who am I, but my opinion is name is probably too narrow. And so I think they wanted to make sure that we are including anything that people reasonably know and associate with a candidate, a ballot initiative, or the party of a candidate that's on the ballot. And Ms. Greenman might have something to add to that.
Mr. Chair.
Yeah, Senator Matthews.
I appreciate that answer. So since the 4 are repeated for all 3 of your buckets, for number 3, about political parties, what's the likeness of a political party? Is it the donkey and the elephant? Or the porcupine, or whatever it is? And are we going to decide what is a cute baby elephant on a little kid shirt versus a political-looking elephant on a political shirt? I mean, that's, as I'm going through, I'm going, I don't know if all of these match to each one of the categories here. I'll throw that out. And finally, let me ask the most obvious question, the elephant in the room, if you were to say, Mr. Chair, that I'd like the author and the Secretary's office to comment on. If Donald Trump is not on the ballot in 2024, which I don't know if he will or won't be either, or any election after that, will a Make America Great Again hat not be a prohibited item in a polling place if he's not on the ballot? I'll give you the loudest, clearest example of that and
Sure.
ask you to put the answer on the record.
Senator
Mr.
Westlin.
Chairman and Senator Matthews, I think we're on the same page, but if former President Donald Trump is not on the ballot, and that is his logo, if you walk into a polling place and he's not on the ballot, it doesn't violate the plain language of the statute. Do I have that right?
Yes.
Okay.
Okay.
Senator
Appreciate that, Mr. Chair.
Senator Matthews, I think that might, the only circumstance that might change it is if you use that as your logo and some of your constituents would walk into the polling place, because now it becomes your logo.
And Mr. Chair, I've had my own logos along the way. That has not been it.
But I think, another example is that former President Obama put a lot of effort into that round image, And I think that was something that was not allowed by election judges as well. And, and they would make people take their shirts off and turn them inside out, and that's legitimate. And I think that logo now is obsolete as far as an election goes, so there might still be people that put that logo on their shirt and try to go vote, and they can't be prohibited. So if that helps answer. Senator Mitchell.
Thank you, Mr. Chair. First, if it helps at all, I will say as an election judge and someone who's run the polling places and who has seen most of these scenarios, they're very, very narrowly looked at because we want everyone to feel comfortable in the polling place. We want everyone to vote. And even if someone has one of these things at the election that violates this, and we say, could you please take the hat off, turn the shirt inside out, and they say no, or if they think it's an overreach, they still vote. We write it in a log, and off they go. So no one that is eligible to vote is ever denied the ability to vote. So there really isn't a chance for an overreach in terms of that because someone's going to be allowed to vote. But I will say, even with that, it's very narrowly tailored. I can say during the primaries this last time around, I was there. There was someone new, someone with a Trump hat came on, and he was like, "Is that allowed?" And we were like, "Yes, absolutely, it is." Like all of us that had been there for forever. That's not an issue on the ballot. He can absolutely wear whatever he wants because it's not on the ballot. So the training on that is pretty clear. So I would first like to say, overall, I support this because it has been hard to train people when there's a law in Minnesota on the books and a different law in the courts, and you're trying to say like, well, this is what the state law says, but in application, this is how we're going to do it. So this will actually be helpful in terms of having one source point for to train judges off of. My question is to the amendment and the 100 feet of a building where a polling place is located. So my concern with that is that, for example, our early voting site where I live in Woodbury is what I would say is the closest thing that we have to a community center. So the polling site is in the basement, there's the early childhood center, there's the city's amphitheater, there's the city's library, connected to the same building is the YMCA. So I was about to drop off a library book one day when I had been door knocking, and I got to the door of the building and went, oh, am I gonna be within 100 feet? And I called the county and said, can I go in the building? And they were like, probably a bad idea. So my question is it the intention for it to be, especially if it's a large interconnected building with different things going on, and actually connected to that was a senior center that I did door knock in? Is it our intention to have it be that expansive that it is the whole building and anything else that people could be doing in there?
Senator Westlin, or Ms. Freeman.
Thank you, Mr. Chair and members. I think that is the way that it is currently written. And I think that is the way that our office has advised folks to be implementing sort of the ban on campaign material. I understand the complication with the question that you asked. But that is how I would read it.
And Mr. Chair?
Senator Westlin.
And I think we want to be clear, too, that what's prohibited is the display of items or campaigning within that period. So I guess I'm wondering, if you're just going into a building to return a book and you don't have any campaign materials, it seems to me you are not campaigning. And that's really what the prohibition is.
So to be clear, I was wearing a T-shirt because
Okay.
I had been door knocking. And the interconnected Now, it was through a skywalk, but the interconnected senior center where we were door knocking,
Senator Bolden, some question. Do you have more to add?
I guess, so that, I mean, should I not have, I don't know. I guess it's hard for me to phrase this question because there is the clear building. The interconnected building, because it was separate enough, we felt it was okay, because clearly I need to door knock the senior center. But anyone going in and out of any of these things that might have had a button, a sticker, not even for me necessarily, would have technically been violating this policy, even if they were just going to the gym or dropping off a book. So to me, I would say it seems possibly over-expansive. I guess that's a comment, not a question.
Thank you. Mr. Chair.
Any comments, Senators?
Senator Mitchell, I will just say, I'm not your legal counsel. I cannot give you legal advice. But I guess in that instance, you know, calling and asking the question, first of all, establishes that you did call and ask the question and that you were advised in a particular way. So if you receive an advisory opinion about what you can and cannot do, I guess I would rely on that. But it's certainly challenging when you have multiple buildings together. But I think the intention is to secure the voting location from campaigning activity. And I would rely on whatever opinion or advice you were given from, I don't know if it was the Secretary of State's office or the CFB or whomever it was.
Senator Mitchell and Senator Westlin, we're going to be laying this bill over, so there is some time to work on any refinements that we need to have. So I've got a list, Senator Rusk, but Senator Bolden is next.
My issue was addressed.
Yeah, thank you. Senator Limmer.
Thank you, Mr. Chairman. Senator Westlin, I'm going to play devil's advocate.
No.
And some campaigns identify not by word, but by color. So if 50 people wearing, let's say, a purple jacket were standing in front of the entrance to a polling place for 3 hours, would that be something to subject an election judge to ask them to leave under this particular bill?
Senator Westlin.
So, Mr. Chair, I will defer, but I guess my tongue-in-cheek response would be if they're standing out there for that long, maybe they're subject to loitering. I think that, again, the intention is when you are in the polling place and within 100 feet of it, you shouldn't be campaigning. And the plain language says, are you wearing name, likeness, logo, et cetera? Now, Ms. Greenman might have something different to say, but again, I always try to go back to the plain language. Now, if there are people just standing out loitering in front of a polling place and they're all wearing a color that's associated with a campaign, does that cross the line? Well, again, they're loitering, so there may be a problem with them from that perspective, but perhaps you have something else to offer besides my off-the-cuff response.
Ms. Freeman?
Thank you, Mr. Chair and Senator Limmer. I would say that there are limitations to who is allowed near a polling location. And so if those people were not voting, did not, for example, if the polling location is at a church, did not work at the church, were not a member of the, credentialed member of the media, and again, there's a list in statute of who's allowed in and near a polling location, those people could be asked to leave. So I think that hypothetical would fall into the category of if someone brought it to the attention of the head election judge, they would not be, they most likely would fall under they wouldn't fall into the category of the people allowed. You can't just hang out for a half an hour after you voted. You have to, so.
Her answer
Senator
is
Limmer,
better.
follow up? Senator Anderson.
Thank you, Mr. Chair. Maybe this is for council, but how recent was the language, the original language before we came up with this bill, or the language to the amendment to the bill? How recent was this language for the Secretary of State put in statute?
Mr. Chair and members, I don't know, but I could see what I can find.
Thank you. I'm just wondering, maybe the author, Mr. Chair, the author would know.
Senator Anderson.
What's wrong with the language that's presently in statute?
So
Senator Westlin.
I'm sorry, Mr. Chair. Thank you, Senator Anderson. So I do have a copy of the current language. It has a long history. It looks like the chapter may have been added in 1988, and it looked like it was maybe amended as recently as 2017. But the current language talks about campaign materials and so forth, but then it goes on and says, and the part that's problematic, I think, is the part that says a person may not provide political badges, political buttons, or other political insignia to be worn at or about the polling place. And that is the part in particular that the court took exception to, because there was no definition in the statute as to what constituted a political badge or political insignia. And so the court, while the court found that the state had the right to draw this line, it's a non-public forum, it was reasonable for them to have some prohibitions on campaigning within the polling place. Their primary objection to the statute was the vagueness of the term political. And so this language goes really to the heart of the problem, which is we don't want campaigning and persuasion and those sorts of activities to be taking place within the polling place or within a fairly close proximity to the the polling place. So that's my understanding of what was objectionable about the old statute.
So, Mr.
Senator
Chair,
Anderson.
Senator Westlin, do you think that this, if we were to pass this and make it law, it would withstand another court challenge?
Mr. Chair,
Senator Westlin.
I'm not a constitutional lawyer. My opinion is I think that this language has been crafted in a way that responds to the issues brought by the Supreme Court. The Supreme Court says it's perfectly okay to establish that you cannot campaign within the polling place or nearby. And I think this language is specifically tailored to that activity and those items that one might be wearing. I would never deign to predict what the Supreme Court might do, but I believe that this is in line with what the court intended in its opinion.
So, Mr. Chair.
Senator Anderson.
Senator Westlin, how many incidents did the state of Minnesota experience with this problem that we're bringing forward here in this bill? How many were brought forth by different election judges or different polling districts across the state of Minnesota? How many people complained or were brought up on charges for disobeying what supposedly the law was already saying that we couldn't, that they shouldn't be doing?
Senator Westlin.
Mr. Chair, Senator Anderson, in what time frame? Because again, it appears to me from the history of the statute that 1988. So this statute has been around in its current form for a long time, and then someone challenged it, and the Supreme Court determined that it was too broad and it was too indefinite. So I guess I can't speak to why in 1988 this was brought forward, but I don't know if there's a history the Secretary of State's office can provide in terms of problems.
Ms. Freeman? You have
Mr.
something
Chair
to
and
add?
Senator Anderson. As Senator Mitchell said, any instances of this are recorded on an incident log. There isn't a criminal penalty for doing this. By way of background of how the case got brought forth and escalated to the Supreme Court, someone was in a polling location and was wearing, I believe, a T-shirt and a button that had a political message on it, but was not directly related to a candidate or item on the ballot. And so they were asked to remove those materials and they refused. And so that's where the lawsuit came from. And it was because they had political materials on, like I said, a T-shirt and a button that had a political message. And because of the way that the statute was written, the guidance from the county to the election judges was to that material needed to be removed. Again, I think the basis of the statute, I can't speak to the legislators in 1988 when they created this, but I think it was in an effort to create that sort of island of calm, sort of away from, to keep campaigning out of the polling location. And what the Supreme Court said is that you are too broad and you need to be more specific. And so that's the on the ballot language, I think, is really the specificity that the court might have been looking for.
So, Mr. Chair.
Senator Anderson.
Ms. Freeman, Senator Westlin, that was one incident that was brought to the Supreme Court, but I'm trying to find out how many other incidences were documented throughout the state of Minnesota in elections, whether it was the last election or previous elections to that. I'm just wondering if you have any evidence to that point. That's what I was asking. Thank you.
I might be taking a little bit of a leap here, but I'm wondering, because we have the initiator of this lawsuit in the audience, if we might ask him to come up and tell us, maybe help answer that question as to how prolific this was, and if it was a single incident, and also a little bit more detail about the incident. Would you be interested in coming up, Mr. Mansky?
See what happens when it comes.
And don't forget to sign into our witness list, too.
Yes. Mr. Chairman.
Just identify yourself and proceed with your...
I'm Joe Mansky, and I guess for those who don't know, a few of you were here when I was here. I was formerly the state election director, and following that, I was the election manager in Ramsey County. And so let me try to address the questions as I heard them. Senator Corrin's line of questioning is precisely what the justices in Washington were discussing, and that is the difficulty of defining exactly what political meant. And it was interesting, and I certainly encourage all of you in your spare time, or if you're stuck in traffic, to pull this up on iTunes or something. You should listen to the Supreme Court deliberations. I was there, and it was really quite informative. But I can tell you that Chief Justice Roberts in particular was very interested in supporting the state's right to control the environment in the polling place to prohibit political activities and campaigning and undue influence on the voters. And what they said was that I, as an election official, could not determine what was political, but you could. And in fact, he said that both Texas and California have laws that were more stringent than ours, and if you decided to go that direction, that would be okay with them. And if you decided to go beyond what Texas and California did, that probably would be okay with them as well. If I can answer Senator Limmer's question, or actually Senator Anderson's question, and I think when you were in the House, you may recall this, Chapter 211B was the last part of the state election law to be recodified. And so this was considered, this whole idea of how to control the polling place to prevent influencing the voters. And so the language prohibiting certain activities was an explicit desire of the legislature at that time. And then a few years later, Senator Luther actually offered an amendment which then bolstered that to include the 100-foot business, so that it was not only would the T-shirts, et cetera, be excluded, Senator Limmer, in the polling place, but up to 100 feet beyond the polling place from the exterior wall of the building. And I can tell you that when I was at Ramsey County and had 2,000 election judges working for me, our instruction to them was that the head election judge would go out in the morning and mark off on the sidewalk where 100 feet was. Because we very commonly had people with all kinds of colored T-shirts who were there to influence the voters, which is legal as long as you are not in the polling place and not within that 100-foot area around the polling place.
Thank you for the extremely accurate answer. Very much appreciated, Mr. Mansky. Senator Rest.
Thank you, Mr. Chairman and Senator Westlin. I am still struggling with Clause 3 and the word likeness there. That seems to be, it seems to be, just a parallel to number 1, and I'm trying to figure out, is it really, would it really be the likeness, and I have 2 questions, but the likeness of a candidate that's associated with a political party? Or I don't see why that word is necessary there. Even though it's, it's just parallel to the issues in number 1, it doesn't, I don't know what the likeness of a political party means. Or maybe it just needs some different punctuation or something. But I have some of the same questions about, and I guess it will be decision of an election judge, but of the use of words. So if a person comes into a polling place and has the word, regardless of what color the shirt is, freedom on their shirt, is that a violation? Or the word vote, or the word abortion? Will that be, if 10 people walk in with a T-shirt that has the word abortion on it, and there's no ballot question or anything, would that be political speech, or that that has the words pro-life on it or pro-choice, and they're on a shirt? Is that political? Would that be? I saw you shake your heads on freedom. Wouldn't be, won't get people's hackles up, but would those other phrases, whichever ones they are, of the ones I mentioned, what happens then?
Senator Westlin.
Mr. Chair, Senator Rest, I think under the old statute, that those might have created problems for the election judge to figure out if someone has a T-shirt that says pro-life, that would have possibly been seen as a political message. If there is no ballot initiative relating to the abortion issue, and someone wore a pro-life T-shirt or I support pro-choice in the polling place, that would not be a violation of the proposed language.
So, Mr. Chairman, so
Senator
Senator
West.
Westlin, what about Black Lives Matter? Would that be a violation? I mean, it's a slogan, it's a political slogan, but if it's not something on the ballot, or is it really going to get down to the judgment of a election judge, that whether something goes over the line if this language, and I would just, you probably could come up with phrases that would get closer to going over the line than the ones I just mentioned, but just curious, but I really am uncomfortable with trying to understand the word likeness.
Senator Westlin.
Mr. Chair, Senator Rest, so the word political has actually been removed completely. The word political has actually been removed completely from this. So really the prohibition is specifically about a candidate, a ballot initiative, or a party. And so the problem before would have been under the old statute where it had the word political slogan, would Black Lives Matter have violated that? Probably. Would some of the other examples you provided have violated that? Yes. And so the point was to really try to create a more concrete, bright line rule that wasn't related to the term political and really relates back to is the apparel, the button, the hat, does it have any indication of a candidate? Whether it's their logo without a name, anything definitely associated with a candidate. So it really has taken that assessment of the word political out of there. In terms of the term likeness, maybe likeness and logo are sort of, as it relates to political party, they may be somewhat interchangeable. I guess at this point, I'd like to keep the language the way it is, just because this is what's passed in the House, and we could certainly have other conversations about it, but sort of the plain meaning of likeness is not dissimilar in this instance, probably to like a logo, some representation of something.
Mr. Chairman?
Senator Rest.
Well, Senator Westlin, I would suggest that maybe your language could be, could instruct the House, and that they would like what you're doing here, and rather than you having to say, well, it's over there, so we have to take it here. No, we don't. But I'm really struggling to understand what ends up being a violation under number 3. And let's say a political party itself took on a slogan like Black Lives Matter, and they put ABC party underneath it. Just ABC, that would be the name of their party. Under a slogan like that, that came to be identified with a political party. Just wonder if that's if that would be a violation. I feel like common sense understand 1 and 2, but I get tripped up on number 3, and maybe it's just me, but I don't know what the lightness of a political party is.
Senator Westlin.
Mr. Chair, Senator Rest. So I think what that's attempting to get to is, so somebody says, okay, I'm not going to wear Senator Westlin's T-shirt into the polling place, but I'm going to wear a T-shirt, big T-shirt that says DFL all over it. And so the political party, specifically to the political party, if there is a candidate on the ballot for that party, you cannot wear anything associated with that party. So a donkey or an elephant, and I think both of our parties have sort of stylized versions of those, the slogan, et cetera. So will there be disputes about whether or not something is a violation? I think that that to get to the procedural question, if an election judge makes a determination that something falls within that category, that this is something that is associated sort of in the common understanding with a political party, the person would be allowed to vote and a note would be made, and that may be reviewed further, and it, you know, if it's reviewed and found that it really wasn't a violation of this, that's a moment of instruction, then that can be more clarification that can be provided.
Well, Mr. Chairman,
Senator
just a
Rest, move along,
just a
please.
final comment. I just don't think you even need the word likeness. In what you just described, that would be taken care of, name, logo, or slogan. I don't see any need for the word likeness. So you can keep it in your bill, but I don't think it's instructive, that's all. Thank you.
And Mr. Chair and Senator Rest, I don't have any big commitment or attachment to the word likeness, and, you know, as we move this through the process, it may make sense to take that one out. And I assume that the only reason it was kept in is because then it's consistent with the language in the other two paragraphs, but I absolutely agree with you that maybe for that particular subsection, maybe it doesn't make sense.
Thank you, Senator Westlin. I'm going to try to move this along a little bit, and so I'm going to first call on those that have not been able to make their comments, starting with Senator Marty.
Thank you, Mr. Chair. Senator Westlin, I like the bill. I wanted to follow up 1 minute, though, because I guess you said we're not going to take it up today, but if there is going to be another chance to look at it, Senator Mitchell's concerns, seems to me there ought to be some way to say, look, if there's a residential building within 100 feet of the building of the polling place, you know, we ought to be able to have some way for somebody to access that. Again, it's the balancing act of it. We're trying to avoid people trying to. The point of the bill is very important, but I think if there's a way to say, look, there's a residential property that's within 100 feet of it, you're not going to be able to get into it without that. It seems to me that on election day, it might be one thing, but in the month ahead of time, if a remote voting location, seems to me that's something you ought to look at. That's only a suggestion if we were going to take it up a different day.
I can add a complication to that, Senator Marty, and that is, what if you had to go out to a vehicle and provide a on-site vote for a person? You know, you don't want someone within 25 feet of that vehicle, and certainly it might be more than 100 feet from the building. So yes, but again, I think we're going down the path that the election judge, as Mr. Mansky said, that this is up to you guys. That's up to you. And I think the you is probably down to the election judge that can make the decision. And really, it's not a violation. It's something to be noted, and we can learn from it too. Senator Swazinski.
Thank you, Mr. Chair. Thanks for bringing this bill forward. I enthusiastically endorse everything in this bill. And for me, I've really enjoyed this discussion. I want to thank all of you that have weighed in. We've been trying to define what is speech, political speech, since the Bill of Rights was written in 1789. And often in today's discussion, the court was discussing pornography in the 60s, and Justice Stewart finally just said, I can't define it, but I know it when I see it. And that's what I'm reminded of in today's discussion. We're just trying to decide what can and happen, and I think the election judges will just know it when they see it and know that this is a violation and follow the rules that is laid out. And so for me, the reason I'm supporting your bill, though, is I love the voting booth. I love walking into that because for me, it's like walking into a mosque or a synagogue or a church. It's just like this, after the raucous and emotional campaign, you walk into this place that's just like calming, and everybody's quiet, and they're just sitting or standing or sitting in their voting booth, and they're exercising one of the most important rights bestowed upon humanity. And so any attempt at all to to take what has been going on for months, years, outside that wall and to make that place a special place. Thank you, Senator Westlin, for bringing this forward.
Thank you, Senator Swazinski. Senator Matthews.
Thank you, Mr. Chair. And I fully agree with the underlying concept too. The Supreme Court asked us for specificity, and I think the discussion is, hey, some terms that we might think are specific might not be all that specific, and that's what we're trying to get at. I'd also like to point out and ask the authors, the Secretary's office, an issue that might not have kept up with what the law has said with 100 feet of a polling place, and we used to have polling places on election day, usually one day only places. Oftentimes it was just for that purpose. Your town hall, your city hall, your school, your church, whatever the location was. And we're now in an era of a 45, 46-day early voting period at a location. And so reading the language of the amendment, we're talking about 100 feet within a building where a polling place is located, and we're explicitly stating throughout the entire absentee voting period. So let me point out, in my district, I have a county where the early voting location is the county government center, and it's a very large building, 2 or 3 stories, and the election and the auditor's desk is at the far end of this building. So you walk in through the front door and you walk a long ways down the main hallway, almost to the very end, and that's the area for early voting. I've done it at that location for early voting in the past. But if we're now drawing the circle around the entire building for 6 weeks ahead of time, people come in to pay a property tax bill, to do something with their vehicle, maybe do something with the title of their property. County social services are there. The health department is there. The county commissioner boardroom, if they want to go to a monthly or week, or I think bi-weekly county commissioner meeting, is in that facility. And so are we suddenly going to have a new limitation just for these weeks because of an election that encompasses the entire building, where we're only focusing on, I think we could all understand, hey, don't influence people that are in line at the early voting booth there at the far end of this building. But under the language, if we don't have specific language, are we going to allow someone that might want to meddle or cause trouble to find someone at the other end of the building that's talking to their county commissioner or at a completely unrelated building to narrow in and hedge out? Oh, this might be a likeness, this animal here on your shirt might be a likeness of this, or a name, or even a candidate's name. I wonder if we need a little more specificity for that, and I wonder if the Secretary's office has considered that concept as they've overseen this new era of the early voting and how that's handled throughout counties, and if they have a suggestion on how to tighten that up.
Senator Westlin.
Mr. Chairman and Senator Matthews, I'll let Ms. Freeman respond to this, but that 100-foot prohibition has been that's in the current language, and I understand that we have early voting, but we've been early voting for a period of time. So, Ms. Freeman, maybe you can offer some explanation of how this is determined.
Ms. Freeman.
Sure, thank you, Mr. Chair and Senator Matthews. So, as Senator Westlin said, it's currently, the statute does apply, the 100 feet does technically apply to absentee periods and places that serve as polling locations right now. So it's something that our election administrators already deal with. I know I personally had a situation with a county commissioner who had a magnet on the side of his car, and he would park in the front of the parking lot, and during absentee times we would have to remind him that he could he take the magnet off of his car before he came in the parking lot and things like that. So it's something that is currently monitored. I don't want to speak for how the legislature could remedy this. I think it's something that we could bring back to locals and ask them, as well as, with your input as well. Sounds like the bill will be laid over, so there might be an opportunity for that. So I don't want to throw out something from our office without having the input of the local administrators at the county and city level on that.
Thank you, Mr. Freeman. Senator Matthews, you follow up? Senator Limmer.
I just wanted to underscore something that Senator Rest said. We shouldn't have to try and duplicate language from the House, from following anything that those people would create. It's important to be possessive of our own role in the Senate. Thank you.
Mr. Chair.
Thank you, Senator Limmer.
Yes, those people. Those people. Senator Limmer, I'm not suggesting we can't do our own thing here. I'm simply saying that this is the language that we have in this amendment was language that conformed with what's come over. That was the genesis of our language. And yes, Senator Rest and I have talked about the House.
Senator Grant.
Thank you, Mr. Chair, and thank you, Senator Rest and Senator Limber, because I also believe, yes, our autonomy is our autonomy, and frankly, their opinion is great, but it's just their opinion in the House. But I do think that 46 days, I think Senator Mitchell did a good job at describing her scenario. Senator Matthews, the same thing. I think the 46 days, I think all of these are far more applicable in that one-day voting, polling place. But the 46 days really ensnares many more people. And so I think when we look at the definition of in here, who are people, right? Who are people? Because in this scenario with the common polling places of early voting, it's a city center, a government center. And so you have city staff, right? You have vendors that are coming in and out of those facilities, all sharing the same entrances and likely violating the 100-foot. You've got a resident, you got a poll worker, you got a voter. I think we really need clarification or a thorough conversation. I don't think anybody here disagrees with the intent. Make it clear and objective. But I think the whole who is the people in this, because it's really not defined, and that ensnares everybody. And I think that's going to be a concern. And then of that 46 days, does that then impede someone's First Amendment rights as an employee of an area, of a business, of whatever they wear? Those are the things I think that have to surely be considered before this could be considered ready for prime time, regardless of what the House passed. So I just think that the definition of the people, and then I think that would help us provide clarity. In the case of Senator Mitchell, if you're campaigning and they're attached facilities, I think we have to identify them and not ensnare anybody unnecessarily and provide clarity for all the poll workers that are out there today. So thank you.
Yeah. Thank you,
Mr.
Senator
Chairman.
Grant. I think we're at the point where we need to move this along. This is going to be laid over, so there is time for people to contact the author and see if there's something that is really that important that we can get some wording changed. I have some things in my mind that I am going to talk to the author about as well. And I think, Senator Grant, you have a good point there that you can't regulate everyone. And also, especially in the places where you have a lot of functions going on at the same time, you can't regulate what everyone wears and where they are in the building, and who's an employee and who's not, and who's an elected person in that building wearing a name tag, things like that. That it's I think there's a lot of complications that need to be worked out. So.
Mr. Chair, as
Senator,
a final word.
Senator Westlin.
We could have a working group, and we could engage council to help us figure this out. And if anyone has any ideas on how to improve this language so that we accomplish the objective that we would like to accomplish.
Everyone has time, raise your hands.
I welcome the bipartisan support, for making this the best bill that we can.
Senator Mitchell, final comment.
I was just going to say, I'll do it if she bakes.
Thank you very much, Senator Westlin. We're going to lay this over for possible inclusion. Thank you. Having no more business, the meeting is adjourned.